regulation, James Madison's view on the limits of federal authority was clear. In Federalist 45, he outlined the boundaries of the general government's power, stating that it could not interfere with the internal affairs of states, including areas like police regulations, state laws, and other matters related to a state's governance. This perspective contrasts sharply with how federal power has expanded over time, particularly in regulating firearms through the Commerce Clause. Interstate commerce. The Commerce Clause in Article 1, Section 8, Clause 3 of the Constitution gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. However, this clause has been stretched far beyond its original intent, allowing the federal government to regulate activities that have little to do with actual commerce between states. A prime example of this overreach is seen in United States versus Lopez, 1995, where the Supreme Court held that the possession of a handgun near a school is not an economic activity that affects interstate commerce. Justice Clarence Thomas argued that the court's interpretation of the Commerce Clause had drifted far from the original understanding. This decision was a rare acknowledgement of the limitations on Congress's power under the Commerce Clause. Similarly, in Gonzales versus Raich, 2005, a case involving medical marijuana, Thomas criticized the broad application of the Commerce Clause. He pointed out that if the federal government could regulate homegrown cannabis used for personal medical purposes, then there were essentially no meaningful limits on Congress's Article 1 powers. The majority's decision in Raich allowed the federal government to ban cannabis even if states permitted its medicinal use, demonstrating the expansive reach of federal regulation. Justice O'Connor's dissent in Raich warned of the dangers of such federal overreach, advocating for states' rights and the ability to serve as laboratories for social and economic experiments. This dissent highlighted the federalism concerns at the heart of the case, arguing that the Commerce Clause should not be used to encroach on states' rights. These cases are particularly relevant to the firearms debate. The principles from Raich and Lopez reveal how the federal government could overstep its constitutional boundaries by regulating firearms under the Commerce Clause. For example, in United States versus Stewart, the Ninth Circuit used Raich as a precedent to hold that Congress could criminalize the possession of homemade machine guns, further expanding federal authority under the guise of regulating interstate commerce. The original intent of the Commerce Clause. Originally, the Commerce Clause was intended to promote trade and economic exchange between the states, not as a catch-all justification for regulating any activity with a tenuous connection to commerce. The Interstate Commerce Act of 1887, for example, was primarily aimed at regulating the railroads, which were involved in interstate commerce. States had tried to regulate this industry, but were found to be overstepping their bounds, as interstate commerce was the domain of Congress. This history shows how seemingly reasonable legislation, like the Interstate Commerce Act, can be expanded into something much more far-reaching. By applying the Commerce Clause to areas it was never meant to cover, the federal government has significantly encroached upon states' rights and individual liberties. The ATF, which regulates firearms under the justification of interstate commerce, operates within this expanded interpretation of federal power. However, if we return to the original intent of the Commerce Clause as a means to promote trade, rather than regulate all aspects of economic life, many federal regulations on firearms would lack constitutional support. In essence, using the Commerce Clause to regulate firearms and other non-commercial activities represents a distortion of its original purpose, allowing the federal government to wield far more power than the Founding Fathers intended. National Reciprocity. The concept of national reciprocity has become a significant legislative priority for the NRA, as highlighted by Wayne LaPierre and Chris Cox in their joint statement following the Las Vegas shooting. They urged Congress to pass national right-to-carry reciprocity, stating that it would strengthen Americans' Second Amendment freedoms. Many gun owners and advocates saw this as a worthwhile goal, echoing the sentiment that national reciprocity would be a step toward greater freedom. However, despite its popularity, national reciprocity is fraught with constitutional concerns, primarily because it involves expanding federal authority over what has traditionally been a state-regulated issue. To understand why national reciprocity is problematic, it's essential to look at the context in which it gained traction. Background: Obergefell versus Hodges and federal power. National reciprocity began gaining momentum after the Supreme Court's 2015 decision in Obergefell versus Hodges, which required all states to recognize same-sex marriages performed in other states. The decision was based on the Due Process Clause of the 14th Amendment, which led many gun owners to argue that concealed carry permits should also be recognized across state lines. While this argument might seem appealing on the surface, it raises significant issues regarding federalism and the balance of power between the federal government and the states. By relying on federal authority to enforce national reciprocity, gun owners inadvertently support the expansion of federal control over firearms. This could open the door to broader federal gun regulations, such as national gun registries or assault weapon bans, which would be much easier to implement once federal authority over firearms is established. The risks of federal control. One of the most concerning aspects of national reciprocity is that it would likely lead to a federal concealed carry permit process. This could result in a national registry of gun owners, which many gun rights advocates have long opposed due to concerns about government overreach and the potential for abuse. Currently, reciprocity agreements between states allow for concealed carry permits to be recognized across state lines without federal involvement. These agreements are the result of state-level cooperation, which respects the principles of federalism. For example, a concealed pistol license, CPL, issued in Michigan is recognized in 39 states because of agreements made between those states, not because of federal intervention. By contrast, a federal reciprocity law would involve the federal government in state matters, which contradicts the original intent of the Constitution and the founders' vision of limited federal power. This expansion of federal authority would set a dangerous precedent, potentially leading to further encroachments on states' rights and individual freedoms. The unintended consequences. The push for national reciprocity highlights a broader issue within the gun rights community: the willingness to accept federal involvement when it seems beneficial, without considering the long-term consequences. While national reciprocity might make it easier for gun owners to carry across state lines, it also opens the door to increased federal regulation and control. This trade-off is not worth the risk, especially considering that states are already capable of working together to create reciprocity agreements without federal intervention. Moreover, federal legislation often comes with strings attached. Even if national reciprocity were passed with the best of intentions, future administrations could easily use the same federal authority to impose stricter gun control measures. The federal government has a long history of expanding its power incrementally, and national reciprocity could be the first step toward a more centralized and restrictive approach to gun ownership. In conclusion, while the idea of national reciprocity might seem appealing to many gun owners, it is ultimately unconstitutional and dangerous. The expansion of federal power over firearms would have far-reaching consequences, and it is far better to maintain state-level cooperation on reciprocity agreements than to invite federal involvement. The risks associated with national reciprocity far outweigh the potential benefits, and gun owners should be wary of supporting any legislation that increases federal control over their rights. Anti-Commandeering Doctrine. It's a surprise tool that will help us later. Mickey Mouse. The Anti-Commandeering Doctrine is an essential but often overlooked principle that plays a significant role in limiting federal power. It may not be a topic that gets much attention, yet multiple Supreme Court cases have been won based on this doctrine. Even the Brady Bill, as it was initially drafted, was struck down because of it. While it may seem out of place to introduce this concept right after discussing the ATF, this is precisely where it is needed. According to SCOTUS blog, the Anti-Commandeering Doctrine states that the federal government cannot require states or state officials to adopt or enforce federal law. Justice Alito, in the 2018 case Murphy v. NCAA, reinforced this view.
The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, i.e., the decision to withhold from Congress the power to issue orders directly to the states. Conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. The Anti-Commandeering Doctrine simply represents the recognition of this limit on congressional authority.
This principle aligns with the National Association of Governors' stance that states act as partners, not subordinates, in implementing federal programs. Historical background of the Anti-Commandeering Doctrine. The roots of the Anti-Commandeering Doctrine trace back to the 19th century. One of the earliest cases, Prigg versus Pennsylvania, 1842, dealt with the Fugitive Slave Act of 1793. The Supreme Court ruled that states were not required to enforce federal laws. Justice Joseph Story wrote in the court's opinion,
"The clause is found in the national constitution, and not in that of any state. The states cannot, therefore, be compelled to enforce them."
This established that the federal government could not force states to carry out federal mandates. In 1992, the case of New York versus United States further solidified this principle. The court struck down a federal law that attempted to force states to manage radioactive waste, ruling that the federal government could not coerce states into complying with federal regulations. Justice Sandra Day O'Connor articulated this view.
Congress may not simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program.
In Prince versus United States, 1997, the Supreme Court ruled against provisions of the Brady Handgun Violence Prevention Act that required local law enforcement officers to conduct background checks on gun purchasers. Justice Scalia, writing for the majority, reinforced the doctrine.
The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers to administer or enforce a federal regulatory program.
Additionally, the Supreme Court ruled in NFIB versus Sebelius, 2012, that the federal government could not withhold Medicaid funds to coerce states into expanding the program under the Affordable Care Act, reiterating that Congress cannot use federal funding as a means to compel state compliance. Implications for firearms regulation. So why does the Anti-Commandeering Doctrine fit perfectly after discussing the ATF? The ATF relies heavily on state and local law enforcement to enforce federal gun laws. With around 2,600 special agents, roughly 52 per state, the ATF lacks the manpower to enforce federal laws on its own. This is where the Anti-Commandeering Doctrine becomes a powerful tool for states that wish to assert their sovereignty. If states refuse to enforce federal gun laws, the federal government is significantly weakened in its ability to impose those regulations. Just as marijuana legalization has limited the DEA's power without state cooperation, so too can states nullify federal gun laws by simply refusing to participate in their enforcement. Nullification and the power of states. The Anti-Commandeering Doctrine is a potent tool that states can use to nullify unconstitutional federal laws. By refusing to cooperate with federal enforcement, states can protect their citizens' rights from federal overreach. The 10th Amendment and the Anti-Commandeering Doctrine are crucial mechanisms for preserving federalism and limiting centralized power, yet they remain underutilized and often misunderstood. As we discussed throughout this book, state-level nullification can be a powerful countermeasure to federal overreach. By understanding and applying the Anti-Commandeering Doctrine, states can reclaim their rightful place as partners, not subordinates, in the federal system. Putting it all together, Scott Adams, the writer and cartoonist, has explained the various ways one can discover the truth. While he lists common sources, he highlights that their reliability often falters. The key, he says, is consistency. My goal in this chapter has been to lay out a consistent thread of logic, showing how historical principles align with current realities. The founders had just fought a revolution against tyranny, and they were deeply suspicious of concentrated government power. Would it make any sense for them to place the authority to regulate arms, the very tools they used to secure their freedom, in the hands of another centralized government? They took care to preserve the power of the states and the people, ensuring that neither would be dominated by a distant national authority. This was their intention behind the Second Amendment. which was meant to empower the people to resist any government overreach, even that of the government they were establishing. If the states fought hard to protect their autonomy before ratifying the Constitution, fiercely debating and crafting their own bills of rights, would they then turn around and surrender their power to a federal government, including the means to resist it if necessary? The consistency of the historical record says no. The states maintain their power and reserve the ultimate authority to the people. Now look at the National Firearms Act, NFA. The stated purpose of the NFA was to impose taxes on certain firearms with the intent to discourage their use. But if the Constitution prohibits the government from infringing on the people's right to keep and bear arms, then isn't imposing a tax to discourage their use and infringement? If taxing a right is unconstitutional, then taxing any firearm or accessory is also an infringement. And if that's true, it raises a fundamental question. Why does the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, exist? This consistent thread through history, from the founders' intent to modern-day policies, suggests that the federal government's role in regulating firearms is, at its core, at odds with the Constitution. The ATF's very existence, as an enforcer of laws that tax and regulate arms, contradicts the original vision of a free and armed populace, capable of resisting tyranny. It becomes clear that federal overreach into gun rights through laws like the NFA and agencies like the ATF is a deviation from the constitutional principles the founders fought to establish. By following the thread of consistency, it becomes evident that the ongoing struggle over gun rights is not just about safety or regulation, but about maintaining the balance of power the founders intended. They trusted the people with arms to safeguard their liberty. Today, that trust remains central to the debate over the Second Amendment and the limits of government authority.